Welcome everyone, and thank you for joining us for this webinar, which we are covering the topic of unlocking from lockdown, the employment law implications of returning staff to work. So I'm Jane Callan, and my colleague Andrew Crammond is joining me on the webinar to discuss the topic in more detail. I'm going to start really with a thumbnail sketch of things like the planning for return to work, including the fact that currently the legal position is that it is an offence for a person to leave their house unless that work cannot reasonably be done from home. What has changed is the emphasis, and it changed with the Prime Minister's address to the nation on Sunday the 10th of May. And it's now an encouragement for those who can't work from home to go to work. So it's a change in emphasis at this stage, and of course the story will develop over time as hopefully the virus comes under control and we can return to some sort of normalcy, although of course that might take some time. So employers are not under an obligation to instruct workers to return to work. They can keep eligible employees on furlough, and the furlough scheme will carry on, we're told, until the end of October this year. So getting the employees back to work, whether you need to furlough people and who you may unfurlough, are issues that really need to be considered and planned for. So health and safety is going to be an extremely important factor. The main points are that you, as employers, undertake a risk assessment, consult the staff on that risk assessment, and set up safe systems of work based on that risk assessment. Now, that's an important development that has been picked up by the Court of Appeal recently and developed by the Supreme Court. It was a point that really wasn't focused upon in past cases. But what the courts are saying is that if you don't set up your systems of work based on your risk assessment, you're starting off from the wrong place. So it's really important to do that. And then, of course, you have to implement the safe system of work and keep those systems under review. We know there are 8 sets of guidance which are settings specific, and you will know about those and will, of course, be implementing those. You've got to remember, of course, that there are those who will be clinically extremely vulnerable. They're the ones that have had the letter from the NHS identifying them as such. And then there are those who are not extremely vulnerable, but are nonetheless vulnerable through those conditions. And you'll have to consider if and how you get those people back to work and what sort of work you will be bringing them back to. You will also need to be sensitive to those that are having to self-isolate, either because they are symptomatic or other people in their household are symptomatic. So those are considerations in respect of what might be broadly called health and safety considerations. You do have to also consider the bringing back people in respect of not discriminating on grounds of, for example, age, disability, or sex, for example, part-time employees and those working atypical hours and so forth. So it's important to consult with people, to give them plenty of notice about returning to work and to take into consideration their fears and concerns. I think it was the Chartered Institute the Chartered Institute of Personnel and Development, who...
CIPD to make that slightly easier.
Yeah, CIPD, make it easier, absolutely. Who did a consultation survey of their membership and found that something of the order of 44% of the employees within that survey were fearful of returning to work. So it's a significant number of staff have these fears.
Yeah, I mean, that's something we will touch on. I was going to go on to do that a little bit more, but I think from what you've said so far, Jane, I think one of the big problems is, I remember giving a webinar, I think it was maybe 4 weeks ago now, maybe, telling people what they should be doing in order to furlough people. I feel like I might find myself repeating similar when we're talking about unfurloughing people, because I don't think it's quite as easy as just sending people back to work, especially when you've got, for example, a group of people on furlough, who, and some of which you might not want back yet. You might need to just furlough some of them and unfurlough some of them. So I think you touched on things like consultation. I think that's really important.
Absolutely. And if you've got recognised trade unions, you must consult through those unions in order to comply with your legal obligations. So that's really important. Andrew, you're going to go into more detail, I think, about some of these aspects. Do you want to pick it up from here?
Jane's right. What we're not going to do is we can't possibly sit and give a full rundown for every industry, for every employer, of the kind of health and safety implications you might face. From an employment law perspective, what is really important, I think, are these. We are in difficult times. There's no surprise to anyone in me saying that. You will have many employers now who, having been encouraged by Boris Johnson quite recently to get staff back to work, and likewise employees being encouraged to go back to work where they can't reasonably work from home, that means bringing people back from furlough. But I think it's equally fair to say that these are still very uncertain times. You probably agree, Jane. No matter what the guidance is, people are still fearful. People are scared. People have families. People have children. They don't necessarily want to return to work unless and until they know, and even then they might need some goading, it's safe to do so. Now, the Employment Rights Act does, within sections 44 and section 100, it provides a level of protection to employees. For example, if an employee makes a complaint that their employer is not following proper health and safety procedures and it's putting them at risk in the workplace, then they may have protection from suffering from detriment in the workplace, or indeed, and more importantly, perhaps, from being dismissed for having raised those complaints. Now, I find this really interesting because as lawyers, I don't know about you, Jim, but it's not often you're engaged with section 44 or section 100, but these seem, to my mind, to be some of the focal points, I think, in what is about to come. Because it doesn't take a great quantum leap, does it, to realise that some employees might say, well, hang on a second, my PPE, that's a big one in the press at the moment, PPE is not right. You're not enforcing the 2-metre rule. My desk is too close to their desk. My workstation is too close to their workstation. So these are things that employees will raise. Now, there are routes. If there are employee representatives or if there is a union, they should be taken through those routes. But if there isn't that kind of route for an employee to take, as long as they reasonably raise an issue, then they will probably get the level of protection that section 44 and 100 gives them. Now, for example, what might that look like? And I think this is really crucial because I can see, Jane, this being quite a problematic area. It doesn't need to be in writing. It doesn't need to say this is a health and safety complaint. It can be an employee going to their line manager on the work floor saying, you're not enforcing the 2-metre rule here. I don't feel safe at work. Now, it's really key, and I think more so than ever, Jane, that employers are actually training their line managers on the ground. A, to work out what a complaint of this sort looks like. B, how to react to that complaint and that they have proper policy and procedure in place and that it's enforced. But importantly, I think, Jane, is how not to react. Because for all employees require protection, that's absolutely right. On the flip side, it's quite easy to see how some employers may feel that it's more problematic to them. They just want to get on with their business. They just want to get making more money as before. They want to return to their trade. And it might feel irksome to some employers that they've got employees making complaints or raising issues.
One of the things that we should highlight is that Section 44 and Section 100 of the Employment Rights Act covers employees. But of course, these are sections which are implementing EU obligations generally. And so it's arguably, and in my view, it's strongly arguable that it goes wider than just employees. I don't know what you think, Andrew.
Workers.
Yeah, and it covers workers.
Yeah.
It's known in the argo as being Lim B workers, and I think it's good practice to extend those principles to your agency workers, 0 hours workers, those LIMBY type workers?
Well, the reality is as well, Jen, and to back you up on that, is, for example, someone who's also raising a complaint about health and safety may also be a whistleblower.
Yes.
And the whistleblowing protections against detriment and dismissal obviously apply to workers in the extended definition beyond employees. So if that's not good enough reason for employers to do what you've just said, then I don't really know what is. But it is really important, because it's all very well and good to have a policy. It's all very good to have something in writing, and I absolutely agree that employers should be doing that. What's more important is ensuring that your ground floor managers, to my mind, the ones who are probably the first port of call for these complaints, know how not to handle someone raising a complaint, because that's where some of the difficulties might arise. Everyone's under pressure, and it can become all too easy for someone to start isolating someone in the workplace or start mistreating them. Even, for example, on decisions on who to unfurlough. If you think you've got an employee who has already made a complaint, and then you decide not to unfurlough them and keep them on 80% pay, that in itself is, in my view, a detriment protected by Section 44.
Absolutely. And you've hit on a point, which is, of course, that line managers who may be a bit have a propensity to shoot from the hip really do need to be counselled, trained, instructed to take reasonable steps in handling these problems that arise from their employees. I'm not saying that line managers are generally like that, but we do know from cases that there are a propensity for some line managers to really sort of become very quickly driven to trying to control the situation in ways when looked at in the cold light of a tribunal really wasn't the appropriate way to handle the situation.
To be frank, Jane, I just think in the current circumstances we are all in, staff on the floor, line managers, middle management, upper management, everyone is just under pressure. Everyone is scared. Everyone is worried. Everyone is concerned for their safety.
And their family.
Yeah, absolutely. You don't have to be a manager who usually shoots from the hip to get it wrong. Yeah. In the current circumstances, it seems to me that we all just need to take a step back and be a little bit more aware, perhaps, of what's.
Yeah, and also it's not. I think not just the workplace as such. One might need to consider travel to work. And the fact that somebody might be wishing to protect others, which may include their own family members, and therefore come within scope of the protection. So it may be, this is an unprecedented, well-worn phrase, unprecedented situation, but it does test the law. It will throw up hard cases. And
absolutely, and I think one of the hard cases, which I know you want to talk about, Jane, is about people who, under those provisions, might get protection because they've refused to return to work. I think that's something you wanted to touch on a bit more.
Yes, indeed. And I think the one thing that we would emphasize is that it is really important, if you're going to try and instruct somebody to either come back to work, or if they are going to leave the workplace because they have a belief, and of course from the point of view of the employee it has to be a reasonable belief based on reasonable grounds that health and safety there is a serious and imminent danger to health and safety, basically. So I think an employer in that situation needs to be very careful that they have considered all other steps that they may take. For example, they may think about speaking to the person, issuing a warning, putting them on other work, measures of that sort before they take what might be thought of as being the ultimate step of dismissal. And consulting generally about what is the fear, what is the basis of the refusing to comply with what must be a reasonable instruction on the part of the employer. So there's quite a lot of hard graft will be needed by managers to ensure that they are working on these issues, listening carefully to what is being said. But there will be people who will be obdurate and for whom it comes to the point where there may be no alternative but to consider dismissal. But an employer will wish to consider all other options before coming to that decision.
Employers really need to ensure that they've done all they reasonably can from a health and safety perspective. In order to, even as a defence, for example, to a claim, because to put it simply, if an employer has done all they reasonably can to ensure the safety of that employee at work, then it makes it less likely that the belief in danger is a reasonable one, or that there is a serious and imminent danger. Now, from a health and safety perspective, as a general proposition, there's going to be an expectation, isn't it, that at least the government guidances are followed. And it seems to me, I think I would go a bit further than that. I think that employers, in the present circumstances, need to be thinking outside the box. You know, they need to be thinking of really innovative ways of ensuring that their staff are safe. And I think the best source of information to help employers is, as you say, speak to them. Speak to the employee, speak to the union, because they are the ones on the ground who recognise the problem.
Yeah. And of course, it does bear repetition that this guidance applies to those who cannot work at home. The default position should be that if work can be done at home, it should be done at home as things currently stand.
Yeah. And so, I think what's interesting, Jane, actually is, and I think we will come across this, is more and more, for example, to do with flexible working requests, even whether they're informal or formal. You're going to have lots of people who might be able to do part of their job at home and part of their job in the workplace. And so the employer might want to think, well, actually, can I allow you to stay at home a couple of days and you come in for another couple of days?
Yeah. Or alternatively, do I extend furlough to those workers? Yeah. That's a consideration, but of course that will only be in place until the end of October, and these considerations are likely to run for the foreseeable future.
Yeah,
the end in sight to this, and it is a fast developing area. So these principles need to be correct and thought through from the very beginning, because if you set off on the wrong foot, that is where potentially things will unravel. And of course, confidence in the employer may well be lost if employees feel that they haven't been listened to, or the steps have not been taken that ought to have been taken. So it's a morale point, it's a confidence issue. And so it's really important that a lot of planning and thought is put into the work environment, working arrangements, who's brought back, who isn't, matters of that sort. And of course, the research is fast developing because there is a lot of guidance about the 2 meter social distancing and one-way systems and so on and so forth that people will have seen in the guidance that has been issued. But the research is developing apace, and there is now research saying that it is really important to look at things like ventilation. So it's not one of those things that you can do and it's done. It has to be reviewed constantly, and I'm sure good employers are doing that in any event.
Yeah, I think that's a really good point, and you make a good point, Jane, which is that you need to get it right now, because, for example, when furlough ends, is I think when the big decisions for employers come, the redundancy decisions, and if you start mistreating someone now because, for example, they've complained of health and safety, or you keep them on furlough because they've complained of health and safety, and that somehow feeds into a redundancy decision-making process, employers are going to get themselves in much bigger trouble.
That they need to document their decisions, and more importantly, have a proper rationale for the decision that they have taken so that they can defend those decisions.
Yeah.
So it's going to be one of those things that's going to be quite demanding of managers and employers. It's not going to be something, as I say, that is once done, that's it. It's going to be a constant pressure to carry on and fulfill those obligations.
Yeah, so I mean, we've talked about health and safety, and of course health and safety is very topical at the moment, and it's right that we do. But, you know, wherever there is a decision which involves an element of discretion, you are right to say that it should be based upon fair, objective, and I would say capable of being evidence bases. But of course, wherever there's a discretion, there's always room for even, for example, discrimination under the Equality Act 2010. And again, I find myself saying this, and I've said it before, but I will say it again because it applies equally to unfurloughing staff as it did, I think, to furloughing staff. You know, things like indirect sex discrimination, Jay. If you make decisions based upon part-time workers, for example, and you continue to, you decide not to unfurlough, i.e. to continue on furlough, part-time staff, for example, you might be putting yourself in the territory of indirect sex discrimination, particularly where there's a detriment if someone's kept on 80% pay.
Yeah, but this is one of the fascinating things about furloughing and not furloughing. The decision to furlough or not to furlough can each be seen as a detriment.
Yeah, absolutely.
Depending on their facts. So it's a peculiar situation.
Yeah.
Very much so. I mean, people, for example, can still complain that it's a detriment to be furloughed even on 100% pay, because they may say that their skills are atrophying. If they're in a skilled employment, they can say, well, actually, it's a detriment to me because I'm not exercising my due skills and myself up to date with contacts or the specialist skills that I have. So it's really one of those in rather peculiar situations.
Well, to flip that coin, Jane, one of the unusual things I think is, for example, those who are returning back to work, so are being unfurloughed, they might even see that as a detriment, particularly, I think, in workplaces where those who are on furlough have had their pay topped up to 100%. Because you will have an employee saying, well, why am I being brought back to work in less than safe circumstances to receive my 100% salary when my colleague is sat at home still getting their 100% salary? Now, of course, these are very difficult economic times and employers have to make extremely tough decisions. But part of their job is likewise to manage employees. And I can just envisage some employees making that point. Can you, Jane?
Oh, absolutely. As I say, it's a really difficult situation. It's going to be very much dependent on the facts, which is why we've emphasized that decisions need to be evidence-based and documented at the time to ensure that they are defensible on proper grounds, and that you guard against making decisions on prohibited grounds relevant to protected characteristics. You really have to be very careful in that regard.
I mean, I mentioned indirect sex discrimination, but there could be a myriad of circumstances where the Equality Act is engaged. I mean, for example, disabled employees, for example, who likewise might be on part-time working. And if your decisions are centered around who's part-time and who's not, that could amount to Section 15 treatment. Employers likewise need to remember that they have employees they might need to make reasonable adjustments for. You know, that can't be lost in the ether of trying to implement health and safety.
It has to be actually centre stage. Yeah. And really great care has to be taken to ensure that those pitfalls are not, as it were, brought about and brought into being, that you actually guard against making decisions that get you into those difficulties.
Absolutely.
And so the best way of doing that is to exercise objective criteria wherever possible, and to evidence it, and to talk to staff, get agreement to what it is that you're proposing to do as an employer, as a manager, because that way, that will help in terms of anything that subsequently comes about later on in the storyline.
Yeah, and sometimes I find it can help, whether this is practicable or not. And sometimes it can actually help to have more than one person making a decision. For example, if there are going to be criteria applied, have more than one person scoring the criteria, for example.
Yeah, which is like a redundancy
absolutely,
thing. Yeah. And to sort of, in that sense, have in mind the sort of approach and criteria that you might have in mind if you were doing a redundancy exercise, so that you can have two people marking, as it were, the criteria that you've selected for the particular unfurloughing or whatever it is that you are implementing at that point, so that you have some objective, as it were, or as objective as can be, assessment of what should happen.
But even then, I think, you know, if and when, we're not going to touch on this in great detail, but if and when redundancy decisions come to be made, even then, I think in these times, what might be the ordinary criteria might need to be looked at. For example, employers quite often will look over the past year, for example, and see what that employee has done over the past year. Lots of employees will have been furloughed.
Exactly.
It would feel eminently unfair to disadvantage someone for having been furloughed.
Absolutely. And the classic example of where employers may go wrong is to think, well, they weren't in the workplace contributing, and therefore they get marked down for that. And there's a sort of subconscious, I would say, assumption that because they weren't in the workplace, they weren't contributing, and to, as it were, elevate those that perhaps were in the workplace, even above those that may have been working from home, for example. So that those things need to be thought through and, as it were, put on the table so they can be addressed in full view, as it were. Yeah.
I suppose the point we're making, to almost to summarize, Jane, is much like when you were making decisions to furlough someone, there were ramifications under the Employment Rights Act, the Equality Act, which could be many. I think the same applies, and perhaps applies even more so, actually now, when we come to unlocking furlough. And pardon the pun, but I think the key to unlocking a furlough is, as you say, taking a step back, looking at it fairly objectively as you can, and documenting what's been said. And if in doubt, seek advice. But unless you've got any more closing comments, Jane, I think we've done as much.
No, I think that's right, and I echo what you say and concur.
Thank you. That was Andrew and that was Jane. Hopefully we all enjoyed listening to our seminar. It's an interesting but difficult area for both employee and employer. If you do have any questions, please do feel free to get in touch with either myself or Jane or one of our team. We'd be happy to help. And I'm sure Jane would echo that.
Absolutely. And of course, this is not specific advice. If you want specific advice, please do contact our clerks and we'll be happy to help. Thank you.